Assalamualaikum warahmatullahi ta'ala wabarakatuh. This lecture will cover the topic of specific performance. So in this topic, we will discuss on the meaning of specific performance, the principles governing the specific performance, and the reasons why the court does not grant specific performance. So first, let's look at the definition. So if you look at the writings on specific performance, many authors have put this analogy by saying that specific performance is like an arrow pointed to the heart of the defendant. In particular, legally speaking, it is a court order to direct a party to perform contractual obligation according to its term. So basically, you have a contract and you seek for specific performance to enforce the terms and conditions of the contract. However, specific performance are not available in some circumstances. For instance, when the performance of the contract has not yet arrived, the court cannot grant specific performance. For instance, if in a contract the performance is only done or can only be done at a certain time, so it does not happen yet. In that situation, specific performance cannot be applied by the parties. Or it could also be in the case of conditional contract, where the obligation of the parties is depending on the conduct. So if the particular conduct is not performed, so it would be unlikely that specific performance is available or can be granted to the parties. The concept of specific performance is based on equity acts in personam, where it is an order specifically targeted against the defendant. Next, we're going to look into the principles governing specific performance. So there are a few principles here. Number one, as other equitable remedies, it is depending on the discretion of the judges to award or to grant specific performance. Secondly, it is a remedy in personam, where the remedies is targeted or is enforced against the other party, against the defendant. Thirdly, as you understand on the need of equitable remedies, it is only available when damages are not adequate to the plaintiff, or specific performance can also be awarded in lieu of or in addition to specific performance itself. Number five, fifthly, specific performance is not affected by waiver. For instance, if the parties has waived his obligation, it does not mean that the parties can also can be discharged from the contractual obligation. Number six, specific performance involve the enforcement of positive contractual obligation. So in other words, you can say it is a kind of mandatory injunction where a party is ordered to perform a particular conduct based on the contract or particular obligation in the contract. And finally, we're going to look into the consideration of hardship or expiry of limitation period. So let's look first at the first principle, that specific performance is a discretionary remedy. Specific performance may be granted upon the judge's discretion and not as a matter of right, meaning that it is up to the court to decide whether the parties is entitled to specific performance. Section 21 SRA says that the jurisdiction to decree specific performance is discretionary, The court is not bound to grant any such relief merely because it is lawful to do so, but the discretion of the court is not arbitrary but sound and reasonable, guided by judicial principle and capable of correction by a court of appeal. If you look carefully at this section, there are a few important points here. Number one, it is discretionary remedy in nature, meaning that it is upon the discretion and conscience of the judge to award or not to award the specific performance. However, secondly, the exercise of the specific performance, the exercise of discretion does not mean that the court can do anything with that. It still needs to be guided by the sound and reasonable exercise of discretion. Number three, the third point is that it must be guided by judicial principle in which the court will rely on, meaning that the conscience of the judges will need to rely on the precedents relating to the exercise of the discretion. And finally, in any event where the discretion is exercised wrongly, it always can be corrected by a higher court. Section 21, subsection 1, A and B, clarifies more on the situation where the court may consider awarding specific performance. The first situation is where the contract gives the plaintiff an unfair advantage over the defendant, though may be no fraud or misrepresentation on the plaintiff's part. So here it means that specific performance can be sought by the defendant against the plaintiff if there is any issue of unfair advantage. Secondly, specific performance can also be granted when the performance of the contract would involve some hardship on the defendant, which he did not foresee, where its non-performance would involve no such hardship on the plaintiff. So for the second situation is when the defendant suffer hardship which he cannot foresee or cannot contemplate. So specific performance can be granted to ensure that the contract is specifically performed based on the terms and conditions of the contract. You can look at the illustrations for the details under the section. In the case of Haywood and Cape, in this case, specific performance of a mining lease was granted, although the mine was unprofitable, but it was later refused for the land purchase because the purchaser had no access to the mining land. In this case, the court, the Justice Master of Rules Romilly says that it must be exercised, the discretion of specific performance must be exercised according to a fixed and set rule. You cannot exercise a discretion by merely considering what, as between the parties, would be fair to be done. What one may consider fair, another person may consider unfair. You may have some set rule and principle upon which to determine how that discretion is to be exercised. So, in brief, what the court said in this case, the exercise of discretion must be done objectively. Sometimes the plaintiff thinks that that is a fair act or conduct, but that is not fair on the part of the defendant. So it is for the court to deliberate on the facts of the case whether specific performance may be granted based on the facts of the case and the conduct of the parties. Another situation is where the plaintiff has done substantial act or suffered substantial losses. Under Section 21, subsection 3, this section states that a case in which the court may properly exercise the discretion to decrease specific performance is where the plaintiff has done substantial act or suffered losses in consequence of a contract capable of specific performance. In this situation, you can see that first, due to the breach of contract, the plaintiff had done the plaintiff had done a special substantial act or suffered losses, meaning that if the plaintiff can prove that he has done a particular act in complying with the contract and damages are not enough, then the plaintiff can bring specific performance as a remedy. Or alternatively, if you suffer losses, so that would be more convincing and a solid case for the plaintiff to bring under specific performance, meaning that damages plus specific performance. Next, the court also can look into the conduct of parties. Here, when there is a gross breach of personal faith and use of threat, this would defeat the purpose of specific performance. So here we're going back to the application of unconscionability, where the court will look into the conduct of the parties. In the case of cooperative insurance society and Argus stores, in this case, the court held that since the disputing parties were large, sophisticated commercial entity whose interests were purely financial, compensation for the innocent party lies in damages and not specific performance. In this case, the court found that damages are enough for the parties, and it should be enough only to give the monetary compensation. So there is no need to pursue on the basis of specific performance as a remedy. In the case of Wong Kup Singh and Joram Rubber Estate Limited, in this case, the plaintiff failed to buy from a defendant a rubber estate within a stipulated period. Therefore, the defendant was disappointed with the delay in the finalization of the sale. The plaintiff was given 1 day to complete the purchase, but still the plaintiff asked for an extension of time. So because of that, the defendant refused to sell the land, and the plaintiff claimed for specific performance to fulfill the promise made by the defendant, to ask for the order of court so that the defendant would comply or would fulfill the promise that they had made in the earlier arrangement. In this case, Justice Raja Azlan Shah said that in this case, time was no longer the essence because the parties has went on a long negotiation. In this case, the defendant should give a reasonable notice of their intention to abandon the contract if the balance of the purchase money was not paid. The ground upon which a court of equity enforces specific performance of a contract affecting land is that it acts upon the equities arising out of the change position caused by the acts of the parties, done in execution of the contract and not upon the contract itself. Plaintiff has averred that and proof and a continuous readiness and willingness to perform the contract. So here, even though there was delay on the part of the plaintiff, but it does not defeat the action of the plaintiff on specific performance. If the defendant is not interested to continue with the contract, the defendant should have given a reasonable and ample notice to the defendant, to the plaintiff. However, it is not done in this case. Therefore, based on that reason, the court held that the plaintiff is entitled to specific performance and the sale of the land shall be executed accordingly. You can also look at the case of Yo Long Seng and Te Tobok and Segar Oil Palm Estate. All right, the second principle that we're going to look into is equity is related to the maxim equity acts in personam. So for specific performance, it's very much related to that maxim. Please go back to the case of Penn and Baltimore, and other cases could include Envy the Anchor Line and also other cases relating to equity acts in personam. All right, thirdly, in order to be able to rely on a specific performance as a remedy, the plaintiff or the applicant must prove that damages are not an adequate remedy. If damages are adequate remedy, the court will not intervene. We refer to section 11 subsection 1. It provides that, except as otherwise provided in this chapter, the specific performance of any contract may, in the discretion of the court, be enforced. C, where the act agreed to be done is such that pecuniary compensation for its non-performance would not afford adequate relief. So under this section 11, subsection 1, clause C, specific performance may be granted upon discretion of the court where pecuniary or monetary compensation is not adequate. In some cases, it is enough for you to recover your right or to claim your rights from compensation or monetary damages. In some other cases, you will see that damages are not enough because that would involve not only the loss of sale, the loss of profit, which you can recover in the form of monetary damages, but also it's very important to take action under specific performance so that the contract will be performed between the parties. Under subsection 2, this is relating to the breach of contract breach of contract regarding transfer of immovable property, which can include the land. Unless and until the contrary is proved, the court shall presume that the breach of contract to transfer immovable property cannot be adequately relieved by compensation in money, and that the breach of a contract to transfer movable property can thus be relieved. So here, there is a presumption, unless it is proved by the parties, that in the contract involving immovable property, compensation would not be enough, unless the parties can prove that that is wrong, meaning that this is a statutory presumption where in the breach of contract involving immovable property, for instance, the land, the sale and purchase of land, the parties are presumably entitled, are assumed to be entitled to apply on specific performance because the breach of contract on the land, sale and purchase cannot be adequately relieved or cannot be adequately covered by monetary damages. But for the movable property, basically that can be relieved by way of compensation. In the case of Afghan Realities, Niram Berhad and Nicholas, in this case, the defendant negotiated with the plaintiff about the sale of share in the Oriental Bank of Malaya. The plaintiff in this case had a reason to believe that the defendant were planning to dispose of their shares in the bank. Therefore, the plaintiff obtained an injunction to restrain or to prevent the defendant from disposing with their share. In this case, Justice Raja Azlan said that applying that is beyond doubt that the agreement to transfer the bank share, which are not available in the open market, can be specifically enforced, for there is no standard for ascertaining the actual loss which would have been caused by its non-performance. Hence, the inconvenience caused to the plaintiff would be irreparable and could not be remedied by damages. In this case, the court allowed the application for specific performance because the shares are not available in an open market. Therefore, only by way of specific performance, the plaintiff can enforce the contract with the defendant. The fourth principle is damages may be awarded in substitution of or in addition to specific performance. Meaning that if you cannot, there are two situations here. You can apply for specific performance plus damages, or you can decide not to proceed with specific performance, and therefore you substitute with a claim for damages. Under section 18, of the Specific Relief Act, it says that the power to award compensation in certain cases. In this situation, the first subsection says that any person suing for the specific performance of a contract may also ask for compensation for its breach, either in addition to or in substitution for its specific performance, meaning that if you, the applicant or the plaintiff, applying or seeking for specific performance, damages can be an addition or a substitution for the specific performance, meaning that you can apply, as I mentioned to you just now, specific performance plus damages, or either one, either specific performance or damages. In the first case, obviously, where damages are not enough, that's why you seek for specific performance. In another case, the second situation, where damages will substitute specific performance, that means specific performance would not be enough, therefore you replace with damages which is more satisfactory to the parties. In cases where specific performance is granted but is not sufficient to satisfy the justice to the parties, that compensation for breach of contract should also be made to the plaintiff. It shall award him such compensation accordingly. This is a situation where specific performance alone is not enough. Therefore, the court can also add damages as an additional remedy. So specific performance plus compensation or monetary compensation. Specific performance in the next situation can be awarded even though damages have been agreed between the parties. So even though compensatory damages is awarded by the court, it does not relinquish the right of the parties to apply for specific performance. Section 19, it says that a contract may be enforced though a sum be named in its as the amount to be paid in case of its breach and the party in default is willing to pay the same. In brief, as I mentioned to you just now, even though the compensation of damages may be awarded, but it does not stop or does not prevent the plaintiff or the applicant to seek for specific performance. In the case of Ibrahim Saidin and Hitam Ali, in this case, Justice Wilson laid down an important principle. He said that no authority has been quoted to me to show that where such a provision appears in an agreement, the purchaser of the property are precluded from claiming specific performance. For instance, if you look at the example of sale and purchase of land agreement, even though the trustee who has breached the trust can pay damages due to its misconduct or unconscionable conduct, the beneficiary, as the plaintiff, still can ask the court to compel the performance of the contract against the trustee. So even though damages is awarded, specific performance also can be awarded together with the award of compensation. In terms of the award of damages, it could be for the part unperformed. Either for the unperformed part is a small or large part. Under Section 13, where a party to a contract is unable to perform the whole of his part of it, but the part which must be left unperformed bears only a small proportion to the whole in value and admits of compensation in money, the court may direct the specific performance of so much of the contract as can be performed and award compensation in money for the deficiency. Meaning that in some cases where specific performance is awarded, but there are some other parts where the unperformed part can be covered or recovered by damages, that can be also be done by court That's why you can look at for the unperformed part, you can recover by way of specific performance or by way of damages depending on the nature of the transaction. This is actually in the situation where the unperformed part is a large unperformed part. So either the unperformed part is small or large, it does not matter. You can both seek for the remedies of specific performance plus damages for the unperformed part. In the case of Tan Seng Kui and Palmer, in this case, the court held that a court may award damages in substitution for specific performance of a contract partly performed, meaning that you can, in some parts of the contract, apply for specific performance. In some other parts which are not performed, you can apply for damages. All right, the next principle that we're going to look into is specific performance is not affected by waiver. In the case of Plenitude Holding and Tan Sri Hu, in this case, the plaintiff purchased a piece of land from the second defendant. The second defendant terminated the contract since they were unable to complete the purchase of the land. The plaintiff claimed that there was an agreement that the defendant would not terminate the agreement and forfeit the deposit. The defendant, however, counterclaimed that this amounted to waiver. Therefore, the plaintiff is not entitled to specific performance because they have agreed to terminate the contract. Therefore, that can be considered as a waiver. The plaintiff, however, disagreed and sought for specific performance, claimed damages, and also cost of the proceedings to be borne by the defendant. In this case, the court held that a court of equity enforces specific performance affecting land because it acts upon equities caused by the acts of the parties in the execution of the contract. The defendants in this case have lulled the plaintiff into false sense of security and that they will be given reasonable time within which to complete the contract. Thus, the plaintiff can obtain specific performance irrespective of the waiver because there is already a promise between them. Therefore, based on that promise, the plaintiff have been persuaded or have been encouraged to pay for the land. So it does not matter that it doesn't matter if the land transaction was terminated, but the plaintiff can proceed with specific performance to claim his right based on the contractual promise between the plaintiff and defendant. The sixth principle is that only positive contract may be performed. So positive contract is basically because specific performance is an order to specifically ask the other party to perform the obligation in the contract. Under Section 24, it says that contract to sell property by one who has no title or who is a voluntary settlor. A contract for the sale or letting of property, whether movable or immovable, cannot be specifically enforced in favor of a vendor or lessor who knowingly himself not to have any title to the property or contracted to sell or let the same. So this is the case where the seller of the property claims that he has the title, but instead he does not have title over the land. So in this case, the buyer, the bona fide purchaser, can bring an action under specific performance to enforce the contract, even though in the first place he has been defrauded or he has been cheated by the defendant or by the trustee or by the seller in that case. We can have a look at the illustration B under the same section for the details.